Good evening, everyone. I am Advocate Vikas Garg, founder and CEO of Law.in. I would like to welcome you all in today's session. We have with us Advocate Anshuman Singh, who is practicing at Patna High Court. He has obtained his degree in law from Mumbai University in the year 2011. He has some past corporate experience in companies such as 3i Infotech Limited in Mumbai and Cholamandalam Finance in New Delhi. He enrolled with the Bihar State Bar Council in the year 2011 and has since then been engaged as an arguing counsel in various matters at the Patna High Court and other forums including Commercial Tax Tribunal, Consumer Forums, Central Administrative Tribunal, Patna District Court, Jharkhand High Court, and before the Special Court (CBI) at Ranchi. He is an advocate on record. Advocate Anshuman Singh has represented private clients in several matters, including commercial matters such as GST related to e-way bill, grant of industrial subsidy to private business houses, money suits, cases of money laundering, and CBI related matters. Contractual matters including forfeiture of deposits and blacklisting, land disputes including title suits, partition suits, and also cases of domestic violence, etc. He is regularly invited to legal seminars to foray his views on current legal issues. He will be taking today's session on the topic FIR, investigation, and charge sheet. I have a small announcement for all the attendees that they can post their questions in the YouTube live chat, which will be taken up by Sir in the end of this session. Now, I would like to invite Advocate Anshuman Singh to start today's session. Over to you, sir.
Thank you. Thank you, Vikasji. Thank you so much for that very generous introduction. I hope and I assume that I'm audible, I'm visible to all the participants. We will begin this session today. My only request being that if there are some legal aspirants or those who are wanting to join judicial exams, if they can also keep a small notebook and a pen so that they can keep writing down certain information that I give in the course, as well as I will also be taking them through certain landmark Supreme Court judgments. If that also I will give them with the citation. So if that also they can note it down, it shall be quite worthy for them and valuable in the future. So, Vikasji, can we start the session then?
Yes, sir, I can hear you. You can start the session, sir.
Okay. I'll start the session. In case I'm not audible, Vikasji, you can just interrupt me at any time and I'll begin this session straight away. This is really a session on the criminal law journey, starting from the institution of an FIR to understanding various rights that an arrested person has when he is arrested, the process of investigation that the police undertakes post the filing of the FIR, and all of that culminating into what is known as the filing of the charge sheet. I assume that this session today is not just going to be valuable for legal aspirants and legal fraternity at large, but even for ordinary citizens who may and must know what their rights are in case a criminal law is put into motion. So it is with that objective that we begin this session today. Ladies and gentlemen and friends, whenever an offense is committed or is likely to be committed, any member of the public in the interest of larger justice has a duty to report that matter. One, that is the first alternative, is that he may report that offense to a police officer concerned. The second option before any member of the public is that he may make a private complaint before a magistrate in the local civil court. Now, besides these two options, there is a third option, that is any person in interest of justice can also do both simultaneously. We will be looking at the entire process of FIR today. Please mark my words when I say that whenever an offense is committed, any member of the public, in the interest of justice, can report the matter to either the police or the magistrate concerned. Therefore, the first question that may arise is it necessary that for me to report an information to a police officer, I need to be a victim, or I need to be an eyewitness, or can I be a complete stranger to the case? You see, crime as a concept is really a wrong against the public at large, and therefore any member having knowledge of the same, in fact, has the duty of reporting the same before the authorities. Therefore, the question of locus standi is completely alien to this very concept of criminal jurisprudence. I repeat myself, the aspect of locus standi is completely alien to this concept of criminal law. In fact, in one of the Supreme Court judgments, and I may cite that judgment for your reference, that is in the judgment of Shio Nandan Paswan versus the State of Bengal, the judgment of Shio Nandan Paswan versus State of Bengal, 1987, Volume 1, Supreme Court Cases, page 288, the Supreme Court has said that there is no need for an eyewitness, even an hearsay witness can be admitted, and therefore any person, simply putting it that way, can lodge an FIR. Therefore, the first question that should really come to a prudent mind is the locus standi. And the locus standi, as I said earlier, is a completely alien concept. Any person who is in knowledge of a commission of an offense can report that matter either to the police or to the magistrate concerned. With that little background and understanding, we begin with first understanding the process of an FIR. You see, the concept of a first information report has been stated in section 154 of the CRPC Code, the Code of Criminal Procedure 1973, and section 154 talks of the proceedings in regards to the lodging of an FIR. At the very outset, I may inform all the participants that the term FIR has not been specifically defined anywhere in the code. The term FIR has not specifically been defined anywhere in the code. Simply put, it is an information relating to a cognizable offense given to a police officer, either orally or in a written format, with a view to put a criminal law in motion. Naturally, if an information is given orally before a police officer, the substance of it and the information must be reduced in the written form by the police officer, and it must be signed by the informant and also entered in the FIR book. This process is very important. When we are speaking of FIR, there is a very important term that we will be acquainted with, and that is information relating to cognizable offenses. Now, what is a cognizable offense? In the definition clause of the CRPC code, the cognizable offense or a cognizable case, as defined under section 2C of the code, states that it is a case wherein the police officer may arrest any person without a warrant. That is all that is to be known with regards to what a cognizable offense or a cognizable case is. As I said earlier, a cognizable case has been defined under section 2C of the code, wherein the police officer has the authority, the competence of arresting a person without a warrant. An FIR must disclose the information in relation to a cognizable offense. Now, you may ask me a question that, as an informant, how do I know that the ingredients or the offenses that I am putting before the police officer are cognizable offenses or not cognizable offenses? As an ordinary member of the public, not being a lawyer, I perhaps may not understand the distinction between a cognizable and a non cognizable offense. For that purpose, to understand whether an offense qualifies for being a cognizable or a non cognizable offense, we must look at, and for that purposes I would request you to have the CRPC manual, in case some of the lawyers or legal aspirants have that CRPC code. At the very back of the book is the first schedule. At the very back of the CRPC code is the first schedule, which speaks of classification of offenses. And if you go to the back of the book and look at that first schedule, you will look at column 4, wherein each and every offense mentioned in the Indian Penal Code has been classified as being either cognizable or non cognizable. Therefore, the first schedule at the back of the code will speak of whether the offense particularly is a cognizable or a non cognizable offense. As I said earlier, a cognizable offense is an offense under which a police officer has the competence of arresting a person without a warrant. It will naturally flow from that definition that a non cognizable case or a non cognizable offense, which is also defined in the code itself, is really a case where the police officer may arrest a person but with a prior warrant from the magistrate. Therefore, in cases of non cognizable cases, the police officer has no legal sanction, no authority, no competence of arresting any person without a prior warrant or prior permission from the court. Before we proceed from this, one aspect that I'd like to discuss on is the evidentiary value of an FIR. Because in many webinars that I've held and in lectures, I've been asked this question as to the evidentiary value of an FIR, whether an FIR really is an evidentiary or a substantive piece of evidence. The strict answer to that is that an FIR is not a substantive or a primary piece of evidence. I will repeat myself. An FIR is not a substantive piece of evidence. What I mean by that is, during the process of trial and during the process of criminal appeal before high courts, a court will have to look at many other pieces of evidences and not just exclusively at an FIR to arrive at a certain conclusion. The purpose of an FIR is to either contradict or corroborate the maker of the information. I will repeat. The purpose of an FIR, and that is where the value it holds, is to either corroborate or contradict the informant with his subsequent statements. With that basic understanding of an FIR as defined under Section 154 of the Code, and understanding the distinction between a cognizable and a non-cognizable cases, we will now try and understand another very basic question related to an FIR. What happens when an informant goes to a police station to lodge an FIR but discloses offenses which are not cognizable but are non-cognizable offenses? I will repeat. As an informant, if I go to a police station to lodge an FIR disclosing not cognizable but non-cognizable offenses, then what is the remedy? If you look at section 155 of the code, section 155 of the code talks of information with regards to non-cognizable cases and investigation of such cases. Therefore, section 155 of this code very specifically talks of as to the situation, as to what happens when an offense in the nature of a non-cognizable offense is disclosed before a police officer. For that purpose, I will read straight away Section 155, Clause 2 of the Code. No police officer, I'm reading Section 155, Clause 2. No police officer shall investigate a non-cognizable case without the order of a magistrate having the power to try such case or commit the case for trial. Therefore, by way of 155 clause 2, which really is an embargo, is really a restriction on the powers of the police officer, the police officer does not have an inherent power to investigate on such case. We will now look at section 155 clause 3. Any police officer receiving such order may exercise the same powers in respect of the investigation as an officer in charge of the police station may exercise in a cognizable case. This means that when an offense in the nature of a non-cognizable offense is disclosed before a police officer, he must take prior permission from the court. Once he has obtained that prior permission, he will investigate into that offense as if it was a cognizable offense and not a non-cognizable offense. A plain reading of section 155 clause 2 and clause 3 will make it very, very clear. For utmost clarity, I will read that one last clause within section 155, which is section 155 clause 4. It says, where a case relates to two or more offenses, of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offenses are non-cognizable. Therefore, if amongst various offenses that have been disclosed before a police officer, even if one offense is a cognizable offense, then in that case, the police officer will investigate in that case, considering it to be a cognizable case, and in such a case, he will not be requiring a prior permission from the court. Therefore, strictly speaking, whenever an information relating to a cognizable offense is disclosed before a police officer, the police is duty bound. Please mark my words. The police is duty bound to register an FIR. As I said, that it is now obligatory on the police officer concerned that whenever an offense relating to a cognizable offense is disclosed before him, he must register it as an FIR. However, in the legal parlance, lawyers will not be unfamiliar with litigants approaching us and coming us and telling us with the problem wherein police officers have refused to register FIRs. Despite the law making it mandatory for police officers to compulsorily register an FIR, what happens if the police officer refuses to register an FIR? This matter came for consideration before the Supreme Court in the case of Lalita Kumari. Lalita Kumari versus the state of Uttar Pradesh. Lalita Kumari versus the state of Uttar Pradesh. The citation is 2014, Volume 2, SCC, Supreme Court Cases, page 1. This is a constitutional bench judgment, a 5-bench judgment of the Supreme Court that laid down the law that whenever an information relating to a cognizable offense is brought before the notice of a police officer, it is mandatory, it is obligatory on the part of the police officer to register it as an FIR. In that very same case of Lalita Kumari versus state of Uttar Pradesh, the Honorable Supreme Court, however, has also carved out certain exceptions. Certain exceptions have been given, such as matrimonial disputes, family disputes, commercial offenses, cases of medical negligence or corruption cases. In such cases, the police officer does have the power, a very limited power, of doing some sort of a preliminary inquiry. Therefore, the Supreme Court in this judgment has said that the registration of an FIR is mandatory. However, in certain exceptional cases, such as the ones that I've stated, such as matrimonial disputes, family disputes, commercial disputes, corruption cases, medical negligence, the police officer has restricted powers of doing some sort of a preliminary investigation before lodging an FIR. But barring and beyond these cases that I've just cited, it is absolutely obligatory on the part of the police officer to register an FIR. As I said earlier, that despite the law, there is every possibility that the police officer may still shoo you off or may refuse to register an FIR. What is then the option before the aggrieved, before the victim or any informant who has gone to the police station to lodge an FIR, but the police officer refuses to file an FIR? The first remedy before an aggrieved has been given in section 154.3, section 154 subclause 3 itself, which says that in case the police officer refuses to register an FIR, the informant can send the piece of information in writing by post to the superintendent of the police concerned. Therefore, if you look at section 154 clause 3, the first alternative remedy when the police officer refuses to lodge an FIR has been mentioned. This is the first remedy before an aggrieved person when the police officer refuses to lodge your FIR. The second remedy is you may also approach the Honorable High Court of your jurisdiction under section 482 of the code. Section 482 speaks of the inherent jurisdictions of the High Court, and by moving a petition under section 482, an aggrieved or an informant can ask the High Court to give directions to the police officer to register an FIR as per the law laid down by the Supreme Court in the case of Lalita Kumari versus State of Uttar Pradesh. These are the two options. The third and the often exercised option is the remedy of making a petition. The third remedy is making a petition under section 156 clause 3 of the CRPC code. When you make a petition under section 156.3 of the code, you basically ask the magistrate to give directions to the police officer to register a case. Now, when you make an application, a petition before a magistrate under section 156.3 of the code, the magistrate has the following options. Firstly, he may straight away on that information that you've given him take cognizance under section 190 of the code. That is the first option or discretion that the magistrate may utilize. The second is he may, as per your request, direct the police officer to mandatorily register a case. Once such a direction has been made by the magistrate concerned to the police officer, it shall no longer be discretionary on the part of the police officer, but to register an FIR. Please remember that in any order passed by a magistrate under section 156 subclause 3 of the CRPC code is a judicial order. It is an order being passed by the magistrate or a court, and therefore it must reflect application of mind and judicial conscience. Let us go one step further at this stage and look at a possibility when, despite the informant going to a magistrate, making a petition under section 156.3, asking him to direct the police officer to register an FIR, and even despite that petition, the magistrate refuses to make directions to the police officer. What then will the remedy for the informant be? If the magistrate refuses to make directions to the police officer under 156(3) of the code, you then have the option of challenging that order under the provisions of a criminal revision before the superior court. Therefore, in case under section 156(3) of the code, a magistrate refuses to give direction to the police officer, the further remedy before the informant who wishes to make uh, a disclosure of a piece of information is to file a criminal revision. Therefore, these are the many options available to a person when a police officer refuses to register an FIR. As I said, the first remedy is to move under 154 clause 3, that is making an information in writing to the superintendent of police. Second is to move the Honorable High Court under section 482 of the code. And the third is to make a petition to the magistrate of your local jurisdiction under section 156(3). You see, before we conclude this aspect of FIR, there are just a few other topics that I'd like to touch upon and which is very important, which is, can a second FIR based on the same set of facts, on the same set of offenses, be registered? Therefore, now what we will be talking about is the provision of a second FIR. Strictly speaking, a second FIR on the same set of facts, on the same incident, and for the same offenses cannot be filed. However, the police officer has the right to conduct further investigation and submit a report when the offenses disclosed in the second FIR have not been disclosed in the first FIR. That is the law with regards to a second FIR. And for the benefit of some legal aspirants, you may note it down. This law was laid down in the judgment of Antony versus the state of Kerala. Antony versus the state of Kerala, cited in 2001, volume 6, SCC, page 181. Okay. There are, of course, many other judgments which speak on the provisions of a second FIR and whether a second FIR would be maintainable or not maintainable. One other important judgment that you may note it down is Amit Bhai Shah versus the CBI. This judgment of Amit Bhai Shah versus CBI was cited, and I'm giving you the citation, 2013, volume 6, SCC, Supreme Court Cases, page 348. Having discussed with you the concept of a second FIR, we come to a very latest innovation, that is the concept of a zero FIR. A lot of us in the legal fraternity or a lot of legal aspirants may have been acquainted or may have come across the concept of what a zero FIR is. Very simply put, a zero FIR is basically an FIR that you can lodge in any police station, irrespective of the jurisdiction that it may have, so that certain investigation for the purposes of urgency can be conducted by the police officer concerned. Therefore, in other words, a zero FIR is one which can be filed in any police station, irrespective of the jurisdiction and the location of the incident being irrelevant. Please remember, the term zero FIR comes from the fact because since the offense is being disclosed before a police station does not have the jurisdiction, the police officer will note it or reduce it in the FIR register as the number 0, which is why it has been termed as a zero FIR. Once it has been registered as a zero FIR, and once some basic preliminary investigation has been conducted, the information of that zero FIR will then be transferred to the police station where the jurisdiction lies. That is, plainly speaking, the concept of zero FIR. Uh, just for purposes of information, the concept of zero FIR was recommended by the Justice Verma Committee in the Criminal Amendment Law in the year 2018, and in many matters such as motor accidents or uh, offences where there are sexual offences concerned. In such cases, and it is with such offences in mind, such as motor accidents and sexual offences, that the concept of zero FIR has been lodged. Let me just give you an example of a zero FIR so that it can be very, very clear to all those attending this session. Uh, if you've heard of the case of the Asaram Bapu rape case, the Asaram Bapu rape case, the information with regards to that, that is the averments of rape, was made on the insistence of the Kamla Nagar Nehru police station in Delhi. It was initially reduced as a zero FIR and then was subsequently transferred to the police station of Jodhpur. That is where the jurisdiction lied. So this is one small example of a zero FIR. This, in nutshell, would cover broadly the concept of an FIR. That is, what is an FIR, what is a cognizable and a non-cognizable offense, the first schedule of the court speaking of the distinction between these two offenses, the judgment of Lalita Kumari versus the state of Uttar Pradesh, which makes it very, very mandatory for a police officer to register an FIR. I've also discussed with you the various remedies that is lies with you or with an informant if the police officer refuses to register an FIR. I've also discussed with you with certain judgments of the Supreme Court the concept of a second FIR and the concept of a zero FIR. Having discussed these aspects of an FIR so far, we will now go on to the next aspect of the topic for discussion, which is that of the investigation by the police. Once an FIR has been registered, it has been reduced in the FIR register book. The next process that the police undertakes is the process of investigation. Section 154 to Section 176 of the Code, under Chapter 12 of this Code, deals with the powers of investigation of the police officer. Therefore, Section 154 to Section 176 speaks of the laws relating to investigation of all cases, whether they are cognizable cases or whether they're non-cognizable cases. The term investigation has again been defined in the code under Section 2H. The term investigation has been defined under Section 2H of the code, and it includes, the definition says that it includes all proceedings under the code for the collection of evidence. So plainly and squarely speaking, by investigation, we mean the power of the police officer to collect evidences. When we are speaking of the power of the police officer to conduct investigation, we will look at Section 157 of the Code. Section 157 of the Code speaks of the procedure for investigation. You see, investigation in itself by the police officer can include many, many steps. It can mean proceeding on the spot once the FIR is registered. It can mean making discovery of certain facts and circumstances. It can mean making arrest of a suspected offender. It can mean the examination of various persons, including the accused. It can mean search of places and seizure of things. When we're speaking of investigation, what is very important to understand is the power of the police officer to make arrest. In fact, the power of the police officer to make an arrest is intrinsic to the police powers of investigation. In fact, if you look at section 157 itself and the last line of the very first paragraph, last line of the very first paragraph will say, and I will read it, and if necessary, to take measures for the discovery and arrest of the offender. Therefore, section 157 itself very plainly says that the power of making an arrest is intrinsic to the powers of the police officer who is making an investigation. So, yes, every police officer making an investigation has the power of arresting suspected persons. Speaking of the powers of arrest during investigation, this particular provision of powers of arrest of the police officer is dealt in chapter 5 of the code, starting from section 41 to section 60. Section 41 to section 60 deals with arrest of persons and rights of arrested persons. Section 41, I repeat, to section 60 speaks of the various provisions dealing with arrest of persons and rights of arrested persons. You see, arrest basically is a restriction on the liberty and movement of an individual. And therefore, time and again, the Supreme Court has gone on record to say that the powers of the police officer to make arrest are not arbitrary powers. These powers to make arrest must be founded, must be based on solid reasons. Section 41 and Section 42, as I said earlier, deals with wide powers of the police officer to make arrest without warrant and without order of the magistrate. However, these powers of arrest are subject to certain conditions. Please remember the word arrest and custody are not synonymous. At this stage now, I will speak to you about a judgment, that is the judgment of Siddharam versus the state of Maharashtra. Siddharam versus the state of Maharashtra, cited in 2011, Volume 1, Supreme Court Cases, page 694. In the case of Siddharam versus State of Maharashtra, 2011, Volume 1, SCC, Supreme Court Cases, page 694, the Supreme Court has gone to the extent of giving certain safeguards to ensure that the power of arrest is not arbitrary. In fact, the Supreme Court has said in this judgment that the powers of arrest may not be exercised when the accused is willing to cooperate in the process of investigation. And similarly, in this judgment, the Supreme Court has gone on record to bring out many other safeguards. And I will request all attending participants to, at leisure, go through these judgments to understand the safeguards given by the Supreme Court. When we're speaking of the powers of arrest by the police officer, which starts from section 41 and goes up right up till section 60 of the code, we must understand two newly inserted provisions. The first provision is with regards to section 41A. I hope all those hearing me are with me on this page, and section 41A, which has been inserted subsequently by the Amendment Act of the year 2008, speaks of the notice of appearance before a police officer. Now, what section 41A says is that where the arrest of a person is not required. However, for reasons to be recorded, if the police officer is of the opinion that the accused is to be arrested, then such persons can be arrested. I will read for purposes of clarity section 41A, certain parts of it. Section 41A, which is a newly inserted provision as inserted by the Amendment Act of the year 2008. The notice of appearance before police officer. The police officer shall, in all cases where the arrest of a person is not required under the provisions of the subsection 1 of section 41, issue a notice directing the person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense, to appear before him or at such other place as may be specified in the notice. Subsection 2 of 41A, where such a notice is issued to any person, it shall be the duty of that person to comply with the terms of that notice. Therefore, basically what section 41A speaks of is the procedure of notice of appearance, which is to be given by a police officer concerned. If you just go uh, the and look at the forthcoming provision, which is that of section 41B, it speaks of the procedure for arrest. What is the procedure and the duties of an officer that he must comply with when he is making an arrest? And it very categorically and simplistically speaks of those procedure, some of it which I will read. Every police officer, while making an arrest, shall bear an accurate, visible, and clear identification of his name, which will facilitate easy identification. So basically, what 41B speaks of is the procedure of arrest and the duties that a police officer must undertake while he is making an arrest. Whenever we are discussing on the powers of the police officer to arrest and the safeguards and the preventive measures that are available to arrested persons, we must refer to a leading landmark judgment of the Supreme Court, and that is the judgment of D.K. Basu. D.K. Basu versus State of West Bengal, 1997, Volume 1, SCC, page 416. The leading case of D.K. Basu versus State of Bengal, as cited in 1997, Volume 1, SCC, page 416, must be referred to because this judgment gives various directions for the preventive measures and the safeguards that the police officer must utilize when a procedure for arrest is being undertaken. The other judgment that I may cite at this point of time is the judgment of Joginder Kumar. The judgment of Joginder Kumar, cited in 1994, Volume 4, SCC, Supreme Court Cases, page 260, speaks of the powers of arrest of police officers during the process of investigation. Therefore, these judgments, that is, the judgment of D.K. Basu versus State of Bengal and the judgment of Joginder Kumar, must be referred. One other important judgment before I proceed further is the judgment of Arnesh Kumar. Arnesh Kumar versus State of Bihar and another. The judgment of Arnesh Kumar versus State of Bihar and another, cited in 2014, Volume 8, Supreme Court Cases, page 273, basically says that the power of the police officer to make arrest must be founded on reasons. It is not an arbitrary power, because there has to be a distinction between the power to arrest and the decision to arrest. Therefore, this judgment of Arnesh Kumar versus the State of Bihar, 2014, Volume 8, SCC, page 273, speaks of various provisions and speaks of the solid reasons that the police officers must have when they're making an arrest, because there has to be a distinction between the power to arrest and the decision to arrest. Having spoken about the powers of arrest of the police officer, we will now speak about the various rights. What are the various rights of arrested persons? When a person is arrested, what are the rights that he has? And this particularly is a subject matter of importance not just to lawyers, legal aspirants, but for every member in the public as citizens to know what the rights are. So we will now be speaking point-wise on the various rights that are available to arrested persons. The first right that an arrested person has is the right to be informed on the grounds of arrest. Therefore, the person who's being arrested must be informed the grounds on which he's being arrested. This has been spoken of in section 50, clause 1 of the code. The second right that the arrested person has is the right of bail in case of bailable offenses. Therefore, in cases of bailable offenses, the prerogative of a bail is given to the arrested person as a matter of right. This has been talked about in section 50, subclause 2 of the code. The third and very important provision is whenever a person is arrested, he must be produced before a magistrate uh, within 24 hours of his arrest. This has been given under section 57 of this code. This particular section, of course, we will talk about a little later when we're speaking on the powers and process of remand. But as of now, what is to be noted down is that the third right that an arrested person may have and has is the right to be produced before a magistrate within 24 hours of his arrest. The fourth and the other valuable right that an arrested person enjoys is that he has a right to consult a legal practitioner, a lawyer. This has been given under section 303 of the code. The fifth right that an arrested person enjoys is the right to be examined by a medical practitioner. The right to be examined by a medical practitioner, and this has been given under section 54 of the code. Therefore, these are some of the rights that every arrested person, as under the mandate of law, enjoys. Specifically speaking on the provision of arrest of women, I would like to draw your attention to section 46. Section 46 of the code. Section 46, subclause 1 of the code speaks of the provisions and the additional measures that needs to be undertaken by the police officer when a woman is being arrested. I will read section 46(1) to make it amply clear. Provided that where a woman is to be arrested, unless the circumstances indicate to the contrary, her submission to custody on an oral intimation of arrest shall be presumed, and unless the circumstances otherwise require, or unless the police officer is a female, the police officer shall not touch the person of the woman for making her arrest. So, under section 46, many additional safeguards have been given, especially when a woman is being arrested. That is, no police officer other than a female officer shall touch a woman. Further, she cannot be arrested after sunset or before sunrise, except in certain unavoidable circumstances. These broadly are the powers of the police officer to make an arrest. And as I've said earlier, by giving you citations of various judgments of the Supreme Court, that these powers to arrest are not arbitrary powers, but are based on reasons. I've also spoken to you about Section 41A and Section 41B. I have also discussed with you the rights that an arrested person enjoys, and specifically the provisions as given under Section 46(1) of the Code with regards to the arrest of a woman. Having discussed the powers of the arrest in some detail, I would now straight away draw your attention to the other very important section of the code while we are discussing on the powers of investigation, and that is the provision of section 161. Section 161 speaks of the examination of witnesses by police. So basically, section 161 of the code speaks of the powers of the police when it is interrogating witnesses. Whenever, in the process of investigation, the police officer is investigating, it has the powers of interrogating any witness, and this includes the accused as well. I will briefly read to you section 161 before we can go further. Section 161, Clause 1. Any police officer making an investigation under this chapter, or any police officer not below such rank as the state government may by general or special order prescribed in this behalf, acting on the requisition of such officer, may examine orally any person supposed to be acquainted with the facts and circumstances of the case. Section 161(2) says, such person shall be bound to answer truly all questions relating to such a case put to him by such officer, other than questions the answers to which have a tendency to expose him to a criminal charge or to a penalty or to a forfeiture. Therefore, what section 161 talks about is the powers of the police officer to interrogate any witness, including the witness. You see, we have in section 161 subclause 2 said that it is almost mandatory for the witnesses to give fair disclosure to the police unless it has a tendency to expose him. Now, this section 161 subclause 2 is really in tune with the constitutional guarantee that has been given to every citizen that no man shall be compelled to be a witness in his own case. Okay? Therefore, in keeping tune with this constitutional guarantee, that is, no man shall be compelled to be a witness in his own case, this proviso in section 161 has been added. Now, the purpose of section 161, that is, what is the purpose of having a section 161 statement before a police officer, has been given in section 162. Section 162 suggests that the purpose of 161 is to contradict the witness by the prosecution. If you will read minutely, it says in the second paragraph of section 162, I will read the first few lines of the second paragraph for 162. Provided that when any witness is called for the prosecution in such inquiry or trial, whose statement has been reduced in writing as aforesaid, any part of his court by the prosecution to contradict such witness in the manner provided by section 145 of the Evidence Act. Please remember that the statement given to a police officer under section 161 is not to be signed. Okay. Having discussed in some sort of brevity section 161, I will go on to the next important section, which is, so section 161 is an examination of witness by police. Section 162 speaks of statements to police not to be signed. Section 163 says no inducement is to be offered because otherwise it will be inadmissible. And then a very important section again is section 164. I'm only taking you through the important provisions of the code when we're discussing this entire criminal law journey. Section 164 speaks of the provisions of recording of confession and statement. Therefore, unlike a statement under section 161, which is made to a police officer, a statement under Section 164 will always be made on the request of a police officer, but before a court. Please remember the distinction between 161 and 164 is that a statement under 161 is made to a police officer, which is not to be signed, while a statement under 164 is made to a court on oath. Okay. Section 164 speaks of recording of statements and confessions. This will happen on the request of the police officer in the absence of the accused, and the recording of either a statement or a confession under 164 will necessarily happen on oath before a court. You see, the purpose of Section 164 is to really bind the witness, so that if tomorrow a witness makes some other contrary statement, then a statement under Section 164 can be brought forward to bind that witness. All right. Now, Section 164 speaks of statements and it also speaks of confession. Confession basically is admission of guilt, and before a confession is being made by the person making it, the magistrate is necessarily under the law has to inform the person making that confession that it will go against him, and such confession being made by the person must be voluntary. This roughly covers Section 161 and Section 164. We now go on quickly to the other important and very important provision, which is that of Section 167. Section 167 speaks of the procedure when an investigation cannot be completed in 24 hours. Therefore, when a person is arrested, as I've said already, under Section 57 previously, which is in fact a matter of right given to every arrested person, he has to be produced before a magistrate within 24 hours of his arrest. Section 161(1) speaks of the procedure when an investigation cannot be completed in 24 hours. Therefore, when a police officer makes an arrest, he will have to mandatorily produce the arrested person before a magistrate within 24 hours. If, however, in that process of 24 hours, the investigation cannot be completed, the police may ask for a further police custody. And it is here that we will understand the concept of remand. When a police officer produces an arrested person before a magistrate within 24 hours of his arrest, the police officer can ask for a maximum period of 15 days for a police custody. Okay. The maximum period that can be granted by a magistrate for a detention of an arrested person under police custody can be stretched maximum to a period of 15 days. Hence, after that, the custody will have to be transferred to what is known as a judicial custody. Okay. 167(2) speaks of the maximum period when an investigation must be completed and a charge sheet be filed when a person is arrested. Therefore, it says, in cases of offences punishable with death, imprisonment for life, or imprisonment for a term not exceeding 10 years, the maximum period of custody, both police and judicial, can be 90 days. For any other offences, that is an offence which is less than 10 years, the maximum period of custody can be 60 days. What happens if the person is arrested, has been sent to custody, but the police fails to submit a charge sheet within that maximum period of 90 days? If it happens so that the person is arrested, a charge sheet has not been filed within that maximum prescribed period, then the person arrested is entitled to be enlarged on what is called a statutory bail. This is a very, very important concept for all listeners to understand. Section 167 Subclause 5 of the code speaks of the provision of statutory bail. That is, if after the period of completion of 90 or 60 days, the investigation cannot be completed, and if the charge sheet has not been filed, the arrested person has to be mandatorily and statutorily released under Section 167, subclause 2. This is what is known as the concept of a statutory bail. Okay? Therefore, when you are speaking of Section 161, you will understand the process of remand, which can be maximum for a period of 15 days when you're speaking of a police custody, and a maximum period of 90 days when you're speaking of a judicial custody. There can also be a concept of interchangeable custody in between, and the concept of statutory bail under Section 167, subclause 5 of the Code. Having finished Section 167 and having discussed the various concepts of custody, interchangeable custody, and statutory bail, we will now very briefly look at Section 172, which basically talks of the maintenance of a case diary. Basically, Section 172 speaks of a case diary or a station diary or a station house report. The main purpose of Section 172 is to enable the court to understand the procedure and the process that the police officer has utilized in the process of investigation. Therefore, the police must maintain a record wherein it will disclose the investigation process it has undertaken and the procedure it has employed. This will all be reflected in Section 172, that is the maintenance of a case diary. That sort of completes also the topic on investigation. So we have completed the process, the entire discussion on FIR, the process, the powers of arrest, zero FIR, things like that, investigation, Section 167, 161, and 164, the difference between the two, so on and so forth. Having discussed that, once the investigation is completed, this culminates into what is known as filing of the charge sheet. The filing of the charge sheet, which basically uh, signifies the conclusion of the investigation proceedings, is filed under Section 173 of the Code. Okay, so Section 173 will speak of report of a police officer on completion of investigation. Now, before I come to Section 173, what is very, very important to understand is what are the other reports that so far can be asked by a police officer. You may note down, some of you who are noting it down. One, Section 157. Section 157 speaks of a preliminary report. 157 speaks of a preliminary report which can be asked from the officer in charge uh, of a police station by a magistrate. The other report is a report under Section 168, which is a report uh, given by the sub police officer to the officer in charge. So these are the other two reports in addition to the final report under Section 173. These kind of questions sometimes come in judicial examinations, and it is only for that purpose that I'm informing the hearing members. As I said earlier, once the investigation is completed, the police will file what is known as a charge sheet, also known as a challan or a completion report, under Section 173. Now, when a police officer files a charge sheet, the contents of which has already been given in Section 173, the magistrate has the following options. If the charge sheet is a positive report, if the police officer says that yes, the allegations that have been made by the informant does make out for a case and we have collected evidences in support of that case, in that case, the police officer can accept that positive report and he can straight away take cognizance under Section 190. This is the first option that the magistrate may exercise. The second option is in case the report is a negative report, saying that the allegations that have been made by the informant in his FIR have not been substantiated. The evidences collected by the police have not been justifiable to support the case of the informant. In that case, which is called a negative report, also known as a referred charge sheet, in such a case, the magistrate may accept that negative report. But if the magistrate accepts the negative report, he will have to mandatorily issue a notice to the informant. I will repeat. When a negative report is filed, that is, when a report says that the allegations that have been stated do not make out for a case, and the person making the information has absolutely the evidences that we have collected do not support his stand, support his information, a negative report is therefore filed. In such a case, the magistrate concerned has the option of accepting that negative report. But before accepting that negative report, the magistrate concerned must mandatorily issue a notice to the informant, to the person making an information in the FIR. This issuance of notice by the magistrate to enable the informant to file what is known as a protest petition. That is, a notice will be issued to the informant saying that the police officer has done its investigation, they've not been able to find evidence to support your stand, and therefore a negative report is filed. Do you have anything to say? In such a case, the informant then has the liberty of filing what is known as a protest petition. He has the liberty of protesting against the negative report. You see, this concept of protest petition has nowhere been described in the code. In fact, if you look at the code itself, the length and breadth of the code, this concept of uh, protest petition finds nowhere in the code. In fact, this concept was first brought as a matter of law in the judgment of Bhagwan Singh versus the Commissioner of Police and others. In this landmark judgment of Bhagwan Singh versus the Commissioner of Police and others, stated in 1985, Volume 2, Supreme Court Cases, page 537, it was for the first time that the Honorable Supreme Court came up with the concept of protest petition, saying that the magistrate must issue a notice to the informant in case he wishes to accept the negative report. He must give an opportunity to the informant who has lodged the FIR to make a protest against that negative report. So the first case that we have discussed is a positive report. The second case that we have discussed is a negative report. There can also be a third case wherein the charge sheet, the report that is filed by the police officer, is partly positive and partly negative. That is, the police officer, in the process of investigation, collects evidences which forms a charge, which forms a basis against some accused, but it has not been able to collect evidences against the other accused named in the FIR. If that is a case, that is a case wherein a partly positive and a partly negative report is filed. In that case, too, the magistrate, under the compulsion, is to mandatorily issue a notice to the informant to enable him to protest against such a report filed by a police officer. Now, please remember, once I have discussed now the process of the filing of a charge sheet under Section 173 and the various options that a magistrate may exercise when a charge sheet is filed before him. Once a charge sheet is filed, and whatever option or liberty that the magistrate subsequently employs, once the charge sheet has been accepted or a protest petition has been filed, then all this happens in a pre-cognizance stage. After that, the magistrate will then take cognizance under Section 190 and then proceed thereafter with the trial of the case. This broadly covers this entire gamut of discussion of FIR, of investigation, and the finale, which is the filing of a charge sheet under Section 173 of the Code, and the options and discretions that a magistrate may exercise when either a positive or a negative report, or when both a partly positive and a partly negative report is filed before him. That, in my opinion, without really going into further discussions, having consumed some time, will conclude now the discussion on this typical process of a criminal law journey, starting with the lodging of an FIR, investigation, and culminating into the filing of a charge sheet. Please remember, what we have covered so far is the proceedings of an FIR. As I stated very much in the beginning, that the proceedings of filing a complaint is also available before an informant and aggrieved. In that case, Section 200 to Section 203 of the proceedings will come into commencement. I think with that, we will conclude this session, and we will now open up for questions and answers. The mic over to you, Vikasji. Can I be heard?
All the attendees can post their question in
Can I
the
be
chat
heard?
box, which will be taken up by the sir now. So the first question is, how can a stranger can file a case on man who is harassing his wife to get share in his father's property?
What is the question? How can a man?
How can a stranger file a case on a man who is harassing his wife? Basically, a stranger can file a case against a man who is harassing his wife.
Yes. You see, the provision in law states that in the interest of justice, any member of the public, whether he has information, simply if he has an information of the offense, can state it by way of an FIR or a complaint. Specifically in this case, where this is a case of a husband being harassed by his wife. Typically in such cases, what we entertain or what we suggest clients to do is to file private complaints before a magistrate. Such cases often go through the route of a private complaint as opposed to that of an FIR.
Okay, sir. So the next question is, final report has not been filed for more than 8 months. What is the procedure to get the charge sheet filed before the court?
Absolutely. In fact, there are many instances which come to us in this process with litigation. Clients come to us and say that an FIR has been lodged, but the police has been sitting tight over the matter. The investigation has not concluded. In such a case, you can move the Honorable High Court, asking them for a direction to the police officer and give them a time frame to conclude the investigation. Once you file a petition under Section 482 of the Code before the High Court, you can ask the Honorable High Court to give directions to the police officer to give them update as to the process of investigation, and then thereafter also direct a time frame within which the investigation must be completed. This is one of the remedies that an informant has.
Okay. Thank you for your answer, sir. Sir, next question is whether police diary report can be checked by the court.
Yes, yes, absolutely, very much, very much. What is a Section 172, a case diary report? In fact, when we are arguing matters of bail in the High Court, many a times before the court issues a bail, directs a bail, the court can, in all its discretion and liberty, ask for the case diary reports, what is called a CDR in the legal parlance. So, absolutely, the purpose of case diary is to inform the court the process that the police officer have utilized in the process of investigation and their various procedures employed. So, yes, the court can absolutely ask for CDR.
Okay. So the next question is, according to CRPC, can we get the copy of case diary?
No. not the accused. No.
Okay, sir. Sir, the next question is, if we know that there is not, the police is not conducting the fair investigation, then what we can do as an advocate?
I hope that's not an advocate who has asked me that question.
Maybe.
Okay. Okay. Anyways, yes, there are a number of instances, when instances have come to light wherein the informant has come and stated that the investigation is not uh, being conducted in a fair and a square manner. Again, the process of is then to bring it before the cognizance of the High Court. Section 482, which speaks of the inherent powers of the High Court in its inherent jurisdictions, have wide powers. So ordinarily, we move a petition in the High Court stating with facts and materials on record that the investigation is not being conducted in a fair and square manner, and therefore directions must be given to the police officer concerned. Yes. So the remedy
Sir,
is to file a petition.
okay, sir. So the next question is, in zero FIR, only jurisdiction matters or non-cognizable offences can also be filed?
You see, uh, whenever you're speaking of an FIR, a non-cognizable offense can never be filed. A non-cognizable offense, if the offenses disclose non-cognizable offense, then in under those circumstances, the police officer will have to necessarily obtain permission from the court. So even if it is a non-cognizable offense and a zero FIR, the police officer will have to take permission from the court. Just to simplify this a little further, Vikasji, many a times informants go to the police station and disclose non-cognizable offenses. Just to make the process easier, at times the police officer on their own, am I audible? And am I audible?
Yes, yes, sir, you are audible.
Yes. On their own, add one cognizable offense, because the law states that if even one cognizable offense is part of the case, then the police officer does not have to take prior permission from the court. So zero FIR basically as a concept is a concept based on absence of jurisdiction. So permission from the magistrate would be required.
So the next question is, how frequent magistrate can reject or set aside the police report?
How frequently?
How
So
frequently?
when a Okay. So when a charge sheet or a final form or a challan is filed before a magistrate, the magistrate can either accept it or he can reject it, or he can even say that, okay, you've collected your evidence, but the investigation has not been very good investigation, and I direct you to make further investigation. These are some of the options that the magistrate has. So he has the option of accepting or rejecting it once, or directing it for further investigation. Once a direction for further investigation has been made to the police officer will go back, make investigation, and then subsequently again file a charge sheet, again which it will then be discretionary on the part of the magistrate to either accept it or reject it, as the case may be.
So the next question is, can the magistrate dispose of summary cases or summon cases, or the same has to be done by the High Court?
I've not touched on the aspect of summary trials and summary cases, so I will not answer it because it will then be a long answer. And since I've not discussed it, I'll just skip this question.
Okay, sir. So in recent case of Sushant Singh Rajput case, the Mumbai police has not lodged the FIR and started the investigation. The magistrate of the local jurisdiction may order police to lodge the FIR.
This is a fantastically interesting question, and I'm glad this topic has come for attention. You see, without going into the merits of the investigation, because the investigation is still in process, the passing away of Sushant Singh Rajput happened under mysterious circumstances. Now, that will be guided by the inquest report proceedings under section 174 to 176. Please remember, the Mumbai police has not filed any FIR. They are going as per the proceedings guided by section 174 to 176 of the code, which speaks of uh, when a murder or suicides or some sort of thing happens under mysterious circumstances. Now, subsequently, an FIR was filed by Sushant Singh's father, late Sushant Singh's father, in Patna. Okay, an FIR was filed here, making certain allegations and averments against Riya Chakravarti. Riya Chakravarti subsequently filed a transfer petition in the Supreme Court, saying, and in the affidavit that was filed by the counsels for Riya Chakravarti, they stated that the FIR that has been filed by the late actor's father in Patna be termed as zero FIR, and that FIR be transferred to the jurisdiction of Maharashtra of the Bombay police station. So, as a matter of fact, the Mumbai police has not registered any FIR because they are going as per the proceedings of inquest report from 174 to 176. The FIR has been filed by Sushant Singh Rajput's father in Patna, and when Riya Chakravarti filed a transfer petition in the Supreme Court, one of the averments made by her was the FIR that was filed in Patna should be termed as zero FIR and therefore it should be transferred. Of course, it was subsequently rejected, and the matter is now being handled by the CBI and other investigating agencies.
So the
So
next
yes, that's
question is if Hanji.
Ji,
So the
that's
next
all.
question is someone is arrested without a warrant. What that person can do?
So the police officer has powers of making arrest with or without warrant. The sections, the provisions in the code specifically speak of such powers of the police officer. When a police officer is arrested without warrant, that is for a cognizable offense, that is within the powers of the police officer, the remedy for the arrested will be to seek for a bail, because he or she has been arrested. Therefore, the remedy will be in filing for a regular bail and not an anticipatory bail. A regular bail, because naturally the person has been arrested already. Okay, so that would be the remedy.
So the next question is how to get the charge sheet filed before the court where the police officer is not filing final report even after the order of the High Court under Section 482.
Okay. The question is, how do you ensure the filing of a charge sheet when, despite the orders of the High Court, the police is not filing an investigation charge sheet? Well, once a police officer does make an affirmative directive order stating the police officer has to file, the police officer then is under a mandate, is under a compulsion to file a charge sheet. And if, despite the directions of the court, the police does not file a charge sheet, then of course it calls for a contempt proceeding, and the police can be called for contempt. The police officer will not do it. Once a direction has been given to it by the High Court, the police officer will have to mandatorily file it in the magistrate, because then it will give a lot of advantage and liberty uh, to the informants and the aggrieved.
So the next question is there any provision against the law which says missing complaint can be filed after 24 hours only?
Is there any provision?
Is there any provision against the law which says missing complaint can be filed after 24 hours only?
Is there any
Is
provision
there
in
any
law?
provision? The law which says na, that a missing complaint can be filed after 24 hours only. So is there any
Yes.
provision against this law?
I don't think so, and I'm not aware of it. I don't think so.
So the next question is the rape case was filed, but it's been 6 months, no charge sheet has been filed. The accused is a police constable. So what a
The
person can do
accused
in
is
that case? The accused
the
is a
accused
police
is a
constable. Is a constable.
okay.
Sir, I am audible?
Yes, yes,
Hello.
yes. You're audible. Specifically speaking of instances of rape, that has a separate procedure altogether. That is, the victim must mandatorily undergo a medical test But if the averments lie against a police officer concerned, and the police officer is reluctant to proceed with the investigation and file a charge sheet, the recourse, of course, will again lie in filing a petition in the High Court. But this is a very, very serious instance, a very serious instance, because as far as the law is concerned, and now with the various developments in law, the provisions, especially with regards to rape, has become very strict and stringent and must mandatorily be followed. Yes.
So, with this, our question and answers round come to an end. I would like to thank Advocate Anshuman Singh for such an informative session and sparing his time out of his busy schedule for this session. With this, we wrap up this session. Thank you for joining this session. Stay safe. Thank you so much, sir.
Thank you. Thank you so much. Thank you. Thank you.